Companies Act Section 3A. Members severally liable in certain cases. 1. Introduction to members' liability in case of reduced membership. Section 3A of the Companies Act deals with the specific liability of members when a company operates with fewer than the legally required number of members. The law emphasizes that if a company, either public or private, continues to function with a reduced membership for an extended period, the remaining members may be held personally responsible for the company's debts. This section serves as a safeguard to ensure that companies maintain the required minimum membership and do not operate below this threshold for long without consequences. 2. Minimum number of members required. The Companies Act mandates a specific minimum number of members that must be maintained at all times, depending on whether the company is public or private. Public companies must have at least 7 members. Private companies are required to have a minimum of 2 members. Failure to meet these requirements and continued operation below this threshold triggers legal consequences for the remaining members. 3. Reduction in membership and its consequences. If the number of members in a company drops below the legally required minimum 7 for public companies and 2 for private companies and the company continues to carry on its business under these circumstances for more than 6 months, the remaining members become subject to specific liabilities. This 6-month grace period serves as a buffer, allowing companies some time to restore the required number of members without immediately triggering personal liability for the remaining members. However, if the company does not correct its membership deficiency within this time frame, the provisions of Section 3A will apply. 4. Liability of remaining members. If a company continues to operate for more than 6 months with fewer members than required, any member who remains with the company during this period and is aware of the company's non-compliance with the membership requirement becomes personally liable for the company's debts. This means that members cannot claim ignorance as a defense if they know the company is operating with insufficient members and fail to address the issue. A. Scope of liability. The liability imposed on the remaining members is specific to the debts incurred by the company during the time it operates with fewer than the required number of members. Any debts contracted by the company before or after this period are not included in this liability. B. Time frame of liability. The liability applies only to those debts incurred after the 6-month grace period, and the personal liability will continue until the company either regains the required number of members or ceases operations. 5. Concept of severally liable members. The term, severally liable, is a key aspect of this section. It means that each remaining member can be held individually responsible for the entire amount of the company's debts incurred during the period in which the company was operating below the required minimum membership. A. Individual responsibility. In practice, this means that any one member who remained with the company during this period can be sued for the full amount of the company's debts. Creditors are not obligated to divide their claims among the remaining members. They may choose to pursue any one member for the total amount owed. This creates a significant risk for members who fail to address the reduction in membership. B. Legal actions against members. If the company defaults on its debts, creditors have the right to initiate legal proceedings against the remaining members. Since these members are severally liable, each individual member can be independently sued for the full amount of the debt incurred while the company was operating with fewer than the required number of members. 6. Example to illustrate severally liable members. To better understand the implications of severally liable members, consider the following scenario. A public company, which is required to have at least 7 members, experiences a reduction in its membership to 5 members. The company continues to operate without adding new members for 8 months, thereby exceeding the 6-month grace period. During this time, the company takes on new debt. In this case, all 5 remaining members, who were aware that the company was operating below the required membership threshold, become severally liable for the debts incurred after the 6-month mark. A creditor can choose to sue any of these 5 members for the entire debt amount, and it will be up to that member to seek reimbursement from the other liable members, if possible. 7. Importance of compliance with membership requirements. Section 3A serves as a deterrent against companies continuing to operate without maintaining the legally required minimum number of members. By placing personal liability on the remaining members, the law ensures that members are motivated to either restore the company to compliance or halt its operations. This provision protects creditors and other stakeholders from the risk associated with companies that are undermembered, while also placing accountability on members who allow such situations to persist.